Hi, Nick Doganor State Law. We safeguard your professional license so you can get back to business. Today, we're going to talk about the different potential penalties that the North Carolina Division of Child Development Early Education can implement against a child care facility, also known as a daycare. So, we talked about in a different video the difference between a written reprimand and a written warning. I'm going to start from the very bottom, which is written reprimand, all the way to the very, very top, which is a revocation and everything in between. I'm not really going to get into much of the written reprimand and written warning because I talked about both of those in a different video. So please check that other video out for more information regarding what a written reprimand is and what a written warning is and the difference between the two of those. Just to kind of back up a little bit, when there is a quote unquote penalty implemented by the Division of Child Development Early Education. It's in the form of a notice of administrative action. So they will actually implement an administrative action against the facility. And then if the licensee wants to appeal that, then they can appeal that to the Office of Administrative Hearings. I also did another video about what is a notice of proposed administrative action. So check out that video. It's pretty short. So it won't take up too much of your time, just to kind of refresh your recollection if you've seen it before, or if you've never seen it, just to kind of check that out and find out what a notice of proposed administrative action is. So getting into the notice of administrative action, you're being notified formally that they are implementing some sort of administrative action. And that could be, like I mentioned, the written reprimand. It could be a written warning. And then if it's neither one of those, then what you're really getting into are starting to get into different types of licenses. And what I mean by that is you can have a provisional child care facility license. You could have a special provisional child care facility license. You can have a probationary license, and then you get into revocation. And a lot of the differences between these different licenses and what they really are they're basically there is one specifically called probationary license. So I can't really say that they're all probationary because that's not technically accurate, but they're all licenses that are going to be not that are going to have some sort of catches to them, some sort of requirements to that the licensee of the facility, like owner, is going to have to make sure that they comply with over a set period of time. And that, say, provisional child care facility license is got to be posted at the facility, and it's got to be in a very obvious place where everybody can see it. So when the parents come in, they'll be able to see it when they drop their kids off. They're probably going to have some questions and things like that. But starting off with the provisional child care facility license, what you're looking at there is it's where DHHS, Division of Child Development Early Education, feels that there's a reasonable effort made by the licensee to remedy previous violations, and they really haven't had a lot of time to make sure that the facility is keeping up with the changes that were proposed to them. So it's just a way for them to make sure that compliance is being adhered to and any of the problems were fixed. And then if there was a corrective action plan that was implemented, which most of the time that there is, that is being adhered to over a set period of time. Now, these can be anywhere from a couple months all the way up to 12 months. They cannot be longer than 12 months, though. I would say a lot of times you're looking at anywhere between 6 and 12 months, depending on what the violations are. If the violations are very minor, then obviously you're going to have a much less of an oversight time frame under a provisional child care facility license. And look, you're always going to have some sort of oversight because you're taking care of kids. So it's understandable, and there is oversight. They can they can come in whenever they really want to be honest with you. My understanding is they usually will have one once a month set up. So you can bet that it's going to be more than once a month if you're under any of these, provisional, special provisional, probationary licenses. So we'll move on to the next one that's a little bit more oversight and the reasons behind the difference between the provisional and the special provisional. We'll get into that right now. So special provisional is the next one up. That's going to be for a max of only 6 months. So, when I was first started looking through these codes and saw this, I was like, well, if special provisional is worse, why is it only for a max of 6 months? And because you're going to be subject to more likely more frequent visits, and probably a stricter compliance and more things that you're going to need to do. So I guess the thought process, and I'm just kind of spitballing, I'm guessing the thought process is, well, we're going to come by XYZ amount of times, maybe once per week for the 6 months versus, biweekly for a 9 month provisional license versus the special provisional. So it's a pretty good indication that they're going to come by more frequently to double and triple check the things that you're supposed to correct. And the other thing to consider, that reason difference between the provisional and special provisional, is with a special provisional license, that means that there was a child maltreatment determination, but they might have felt that the children were not actually harmed. And I know that sounds silly, but you can have a child maltreatment for a lot of different things where children were not actually physically harmed. So if there is a determination of child maltreatment, then you're not going to be able to get a provisional license, first and foremost. You would have to get at least a special provisional, if not a probationary license. So that's one of the other differences between the three of them as well. And that's probably why that it would be not to exceed 6 months also. That might factor into it if I had to guess. But I think more than anything, I think what factors into the not exceeding just 6 months versus not exceeding the 12 months for the lower license is that you're likely to have more visits to show compliance with whatever you had an issue with previously, right? And then we'll move on to kind of the next one, that's probationary license. And this is where DCDEE has determined that child maltreatment has occurred, and that they have felt like the violation was willful also. So again, it's kind of like another thing on top of what was found for a special provisional license to be issued. Like, hey, not only do we have a substantiation of child maltreatment, but we have evidence to believe that you did this on purpose and this was willful. Or it could also be where the operator facility has already received a written warning for the exact same thing, or already had a provisional license and then failed to comply with the terms of that provisional license, so they can turn around and do a probationary after all those. And it's got to be the same exact thing. If it's something different, then that's a different track. That's a different penalty track, so to speak. So let's say, for example, your out of staff to child ratio, or I take a better one. Like, let's say lack of supervision, because lack of supervision can have a child maltreatment substantiation to it. And you did everything that you were supposed to do, and you received a written warning, everything was kosher. A year goes by and you got a lack of supervision again. Then you're more than likely to end up with a probationary license, because you've already had the written warning before and you did the exact same thing like a year later or 2 years later, or whatever the case may be. Time does factor in there, by the way. I mean, if you haven't done anything in 10, 15, 20 years, then yeah, it's going to be a different story than if you'd done something like 12, 24 months ago and it was the exact same thing, right? So these probationary license, they cannot exceed 12 months. So they're similar in certain respects to the special provisional license. That length of time is 12 months. There's a lot of differences. There's more differences between the two types of licenses than there are commonalities. The one main difference being or one similarity, I should say, being the length of time. So just no longer than 12 months. So those are the three different types of licenses that can be issued if there is a notice of administrative action. And then, like I said before, you want to make sure that it's in a really obvious place. Parents are going to ask some questions. That's just inevitable. All this stuff's going to be online anyways. So you just have to have kind of like, make sure that your staff's aware of what the proper answer would be. Or if you want to kind of control what, you might want to tell your customers, tell your staff, like, hey, if somebody asks about that, tell them to see me. And then you can kind of have a letter that goes out to everybody, whatever the case may be, kind of explaining like, hey, I can't get into details about this, I don't really agree with everything that happened and the administrative action and new license that we were issued, but I want to make sure everybody understands that everything was corrected, no children were harmed, if that's the case, and et cetera, et cetera. So you do want to be very, very careful about what you put in and you communicate to the parents, but you also want to make sure that they understand, what happened. And you definitely don't want to get into any names or anything along those lines either. So keep it kind of vague, be truthful, but don't get into any details. So, all right, and then obviously the very last one, and this should be set for the most egregious of egregious allegations, and that's a revocation. And this is if there is child maltreatment has occurred and the child was harmed. That's where revocation of the facility license comes in. Now, have I seen them do revocations at the drop of a hat where a child wasn't actually harmed? Yes, I have seen that multiple times. Usually, if it's a situation where there's some deceit going on or something along those lines, or it's a repeat offender multiple times and there's a bunch of violations, then you will see a revocation when there's a child hasn't been harmed. Now, if a child has escaped from a facility, and that happens a lot. I have been very surprised the amount of times that little escape artists have escaped from childcare facilities and wandered down the road. Obviously there's a potential for harm for the child. Technically they weren't harmed, but that is grounds for revocation. I've seen that pretty frequently when there is a little escape artist that wanders from the facility. I have thankfully all the kids that I have seen that have escaped from the facility, they're usually found like within minutes by a passerby or a law enforcement officer or a first responder or somebody like that. And then they're safely returned back to the child care. The parents are called, everybody's fine. But obviously, got to make sure your facility is secure because, if you got a kid like mine, you turn your back for a second and they're upstairs or they're out the door or something along those lines if you're not eyeballing them very carefully. So you want to make sure that your facility is very secure so you avoid stuff like that. But obviously revocation, nobody wants to have that. If you say you get a notice of administrative action, you get your notice of proposed administrative action, they come back and say, well, I still want to stick with revocation, and they give you a notice of administrative action as revocation. Don't freak out. Or try not to freak out. I know it's easier for me to sit here and say, don't freak out, but try not to freak out. What you want to do is you want to make sure that you get a petition for contested case hearing file within that 30 days, okay? Because you got 30 days from when it's sent to you. Not from when you receive it, from when it's sent to you. That's huge because there's case law on this as well, by the way. So, if you need any help or you need to kind of like get calmed down or whatever the case may be, give my office a call, 919-521-8810. You can also text us there. You get a free 15-minute discovery call. And if we can't help you out, we'll find somebody to get you to help out or get to help you out. Okay. If you got any questions on this or anything else, check out the blogs on my website. It's northstatelawfirm.com. You can also check out the other videos on this YouTube channel, North State Law's YouTube channel. And then, like I said, if you do have some sort of notice of administrative action, stay calm, give us a call or give us a text, 919-521-8810, and you can get that free 15-minute discovery call with a member of my staff. Thank you so much for taking care of the kids in North Carolina. Keep up the great work. Bye-bye.